no one I know that's figured out a way to predetermine who's going to be selected or what judge you're going to get. You don't find out until you take your complaint into the clerk's office, and one of the judge's names is randomly drawn from the judge's selection process. The question then is, and I'm going to turn to Boris Feldman for this, but the question then is, can you do in federal court what you can do in state court by way of peremptory challenge? Boris?
Steve has described what happens with essentially the judicial equivalent of the lotto game. You go in and the ball pops up and you find out which judge you've got. And unfortunately, the basic answer is you're stuck with that judge. I'm going to describe briefly what you need to do to disqualify a judge in federal court, but before I do that, I should urge you never to do it unless you know you're going to win. Because, as Doug pointed out initially, you're stuck with that judge through the life of the case. This isn't something where you may have one law and motion judge and another trial judge and another discovery commissioner. You will be coming back to that judge in that case again and again, and unless you know you have clearly persuasive grounds for disqualification, don't try it. There are two statutory bases in federal court for getting rid of a judge. One is Section 144 of Title 28, which is also known as the Judicial Code. And that's a procedure whereby a party, generally through counsel, submits an affidavit alleging either personal bias or prejudice on the part of the judge in favor of or against one of the parties or in relation to some of the issues in the case. And if you read Section 144, it looks an awful lot like Section 170.6 of the Code of Civil Procedure. In fact, it does nothing like what it purports to do. You can't just come into federal court and file an affidavit saying, I think this judge is going to be unfair to my client. It has to be a sufficient affidavit. And what courts have done is read into that sufficiency requirement the substantive rules of the other way of getting a federal judge removed, and that's 28 U.S.C. Section 455. Section 455 provides a mechanism whereby the judge recuses himself or herself in the case based on a number of things. One basis for recusal is personal bias or prejudice on the part of the judge. And another, and by far the more common in federal court, is the financial interest in the subject matter of the litigation. As I indicated, even though Section 144 suggests that all you need is an attorney's affidavit, as you would under 170.6 in state court, the case law is clear that the substantive test is the same under either section. With respect to personal bias or prejudice, the likelihood of getting a federal judge to recuse himself is very slim. Some of you may have read recently about the Apple computer litigation against Hewlett-Packard and Microsoft, in which the judge sitting on the case has a son who's employed by one of the defendants. And that judge ruled that the fact that his son works for one of the parties is not sufficient to establish bias or prejudice. And under the case law, that decision was clearly within the judge's discretion. It is difficult, almost impossible, to overturn a judge's refusal to disqualify himself on grounds of bias or prejudice. With respect to the financial interest in the subject matter of the case, the standard is almost as extreme but in the other direction. If a judge or a member of the judge's family, and the statute specifies what degree of relationship is adequate, has any financial interest in the case at all, then the judge must recuse himself, even if everyone agrees that it wouldn't bias the judge in that case. An example of that some of you may be familiar with is in the cement industry antitrust litigation, in which after about 6 years of litigation, it appeared that the wife of the judge held a few shares in a mutual fund. The mutual fund held stock in a company that was an absent class member in one of the classes. And in the event of a complete recovery for plaintiff, the judge's wife would have benefited to the total of under $1. And the judge recused himself. The decision was affirmed by the Ninth Circuit and by the Supreme Court. It is an absolute statute. One thing you should do if you draw a judge that you're not happy with is check the financial disclosures right away. Judges are required to file publicly statements of what companies they own stock in and certain other financial transactions, and you should look at that at the beginning of the case. If you wait until things aren't going your way in the case, and then you check that and then ask the judge to recuse himself, he would still be obligated to do it. There's no timeliness requirement for this, although the likelihood is that the judge will remember that you waited. And in addition, whichever judge replaces the judge who recuses himself may well just adopt the ruling that the first judge had. So it's not something that you want to wait to try. Procedurally, One of the reasons I indicated at the beginning you shouldn't bring this disqualification motion unless you're sure you'll win is that it is generally decided by the judge you're seeking to have disqualified. So you stand up in front of that judge and say, I don't think you're fair. I think you should get out of the case. Under Local Rule 205-3 in the Northern District, a judge can refer an affidavit under Section 144, which is the party's challenge, to another judge who's chosen at random to decide. In the event that a judge is disqualified or recuses himself, then reassignment is random. You can't specify what judge you would like to get to the case. Just one tip on what you can do to ameliorate the risk of getting a judge that you're not happy with if you're the plaintiff is file parallel actions in federal and state court, assuming that there's subject matter jurisdiction in both. And in that event, you can see whom you draw in federal court, and if you're not happy with that, dismiss the federal complaint without prejudice before there's an answer, and then proceed in the state court action. But again, just to urge you, I would think a very long time before ever asking a federal judge to disqualify himself other than on objective financial interest grounds. Another subject related to which judge you get and which judge you keep is the related case doctrine. And the related case doctrine relates in part to a theme that I think we'll all be touching on repeatedly tonight, which is that the spirit of the Federal Rules of Civil Procedure is to get big cases, to draw in all the parties and all the issues conceivably related to a dispute, to wrap it up in one efficient litigation instead of having different little lawsuits related to each other over a course of years. One way the federal rules try to achieve that kind of efficiency is by saying if there are cases that are related, they should be before the same judge and heard together. The local rule that governs this in the Northern District of California is 205-2, and it creates a very broad test for what is a related case. One possibility is that the cases purportedly related involve the same parties and are based on the same or similar claims, and you don't need all the same parties. A second test is whether the same property, transaction, or event is involved in the related cases. And the third test is whether there are substantially the same facts and the same questions of law in the related cases. You should know that counsel are obliged to notify the court if cases are or arguably are related. If you're about to file an action and you know that there's a similar action on file, then you indicate that to the clerk when you file it initially. If you're a defendant and different plaintiffs that may not know about each other are filing cases against you, it's your responsibility to notify the court and all parties so that those cases can be drawn together. If you file a notice of related case, then you need to attach a short statement of the reasons why assignment to a single judge would affect judicial economy. And then the judge who's drawn the case with the lowest docket number, in other words, the first case filed, advises the assignment committee of the related cases. And generally, the lowest number case, the judge with the lowest number case will get all the related cases. You should also keep in mind that one way not to get around this rule, or not to get away from a judge you don't like, is to dismiss the case without prejudice and then refile it in federal court. They've closed that loophole. So if you draw a judge that you're not happy with, you dismiss, you wait a month, refile the case, then you are obligated under the rules to notify the court that there was a previously filed case that was dismissed involving the same subject matter, and the case will then go back to the same judge, so that you can't get around it that way.
Now that we have some idea of how the judge is assigned, and in fact really how difficult in practical terms it is to remove the case or get the case transferred from that judge to another judge, the question becomes, what about federal court as opposed to state court? What does it take to get into federal court, to get into this process where there's a single assignment judge, where the judge has all the resources that Doug referred to, the law clerks and the externs, the courtroom deputies and whatnot? The answer to the question relates directly to subject matter jurisdiction and what kind of a case can be brought in federal courts. There are a couple of things about federal subject matter jurisdiction that are critical. One is that you cannot stipulate to it. You've either got it or you don't. Similarly, you can't ever be deemed to have waived your right to challenge it. In other words, you can never be said to have waived your right to say there is no subject matter jurisdiction and this case has no business being in the federal courts. In fact, it can be challenged at any time, and in fact, there are cases where if there is not subject matter jurisdiction, it can be brought up for the first time on appeal and the case dismissed. So it's critical to understand what subject matter jurisdiction is and to know that you have it from the outset. It has got to be demonstrated on the face of the complaint. In other words, the allegations of the complaint itself have to make it absolutely clear that you have subject matter jurisdiction in the federal courts. And in fact, in the Northern District,